And a very good morning from Johannesburg. My name is Sebenzile Nkambule. I am the Executive Officer for Strategic Partnerships at the Other Foundation. It's a great pleasure to be with you for this webinar focusing on litigation and policy reform in Southern Africa. The Other Foundation is a Southern African LGBTI community foundation that advances the equality, freedom, and social inclusion of homosexual, bisexual women and men, and transgender, intersex, and gender non-conforming people. It supports LGBTI plus activists and ally groups to work effectively for lasting change, recognizing the particular dynamics of race, poverty, inequality, sex, national origin, heritage, and politics in our part of the world. It does this through fundraising, grant making, and movement building. Our starting point as a foundation is that in all the countries that it works, there remains a great deal of work that needs to be done to achieve just and democratic societies where everyone is free to live a safe and a dignified life, to have a family and make their contribution to society. In other words, the foundation does not seek the simple integration into or equality for LGBTI plus people within existing unjust systems. The foundation's work has a transformative agenda. This particular conversation is really meant to help us locate really and understand what really has been the reality for our community, or particularly the last almost 2 years living under COVID-19 conditions, but over time as well, building on the work that has been done by activists over the years to achieve policy reform, to, of course, also have some litigation victories as well on the continent. And I'm very excited to be joined by very esteemed panelists who I will introduce in just a moment. Southern Africa is seen to be nearing a tipping point of change in recognizing the fundamental rights of LGBTI plus people. And the momentum of activism of this nature in the region that has yielded significant progress towards equality and social inclusion in previous years has been stalled as a result of the COVID-19 pandemic and COVID-19 restrictions and undertaking conventional advocacy activities. Activists in the region have not had adequate opportunities to regroup and re-strategize about how to innovatively undertake effective advocacy activities in the post-COVID-19 context. This conversation this morning is meant to reinvigorate public advocacy for social inclusion by LGBTI plus human rights activists in the new environment brought on by the COVID-19 pandemic. We're, of course, part of and participating in Copenhagen 2021 World Pride activities. And this is indeed a galvanizing moment to initiate more joined-up, strategic and hard-hitting public advocacy actions by LGBTI plus activists in our region. And we believe that Copenhagen 2021 presents the perfect opportunity as well, a catalytic opportunity for the region to come together in a more focused way, to share learnings and develop COVID-19 appropriate advocacy strategies, and of course, to chart a way forward and plan on how to then implement them. I'd like now to introduce my esteemed panelists who are spending some time with us this morning to give us a sense of their context, particular to where they are located, and then, of course, broadly for the region. First, we have Melusi Smelane, who is indeed one of Eswatini's most recognizable activists. Melusi is a name that is synonymous with human rights, as the founder of Eswatini Sexual Gender Minorities, ESGM. Smelane uses his voice to bring awareness to the conditions under which the LGBTI plus community and all minority groups live in Eswatini. In challenging power, Melusi's approach is guided by the belief that change cannot be achieved without mutual respect and consultation. Melusi's advocacy holds the ideals of slow and steady change in high regard as a means of attaining long-term consistent reform of current societal, legal, and governmental structures. We're then also joined by Liberty Matesa. Liberty is the Executive Director of Gender Dynamics, an anchor trans-led and trans-specific human rights organization for the trans movement in Southern Africa. Identifying as a trans non-binary woman, she or they hold a master's degree in law, cum laude, focused on non-discrimination and marriage equality for transgendered persons in South Africa. Liberty also holds qualifications in project management, leadership, financial management, and strategic business management from the University of Cape Town. She or they can be defined as a community-centered, critical thought, human rights, and social justice activist whose passion in fighting for dignity, equality, and freedom for trans and gender diverse persons drives their dedication to achieving positive change. Author to a self-published book, A Darling's Journey to Liberty. In their spare time, they enjoy playing tennis, writing, and painting the rural hometown of Darling. And then last but certainly not least, Kane Youngman joins us also on the panel. Kane is a staunch believer in an all-inclusive protection, promotion, and defense of human rights. His extensive experience in human rights advocacy, strategic litigation, and has been in the human rights sector for 16 plus years. He's worked for the protection, the promotion, and human rights for many inclusive LGBTQI plus children, sex workers, prisoners, women, immigrants, and people living with HIV. Currently, Kane is the head of policy and legal advocacy at the Lesbians, Gays, and Bisexuals of Botswana, also known as Lekhabibo. And it's under Lekhabibo that has led Botswana's litigation victories, including the 2019 decriminalization case. Kane has extensive experience in training for societal change, regional and international advocacy, community and movement mobilization, policy change and development, SRHR, and advocacy. Kane is a dedicated, resilient, and eager champion of human rights who has and still firmly stands for human rights. He's a social scientist by profession, a very, very highly esteemed panel that we have with us this morning. And thank you all as well for joining us. Remember, you can send through your questions via the chat as well as the conversation goes. And as we moderate the conversation, we'll then pick them up while our panelists speak. So let's jump straight into it. And we'll now start and invite Liberty to begin the conversation for us by speaking to the realities in South Africa, and of course citing in particular a very important case related to litigation. Liberty, over to you. Good morning.
Good morning, Sibenzile, and thank you to the Other Foundation for convening this panel during World Pride, and hello to everybody that is joining us today. So I think I want to start off by just stating that COVID-19 really changed the landscape in which we conventionally, of course, operated in from advancing our advocacy objectives. It has also very much exacerbated many of the challenges, the existing challenges that we experienced before the pandemic set on. In many regards, our advocacy efforts were undermined because as an advocacy organization, we then had to pivot our attention towards service delivery in order to meet some of the material and emergency needs of community members. Up until to date, we know that Africa is still very much on the back burner when it comes to access to vaccines and vaccination justice. As of yesterday, South Africa, for example, only got access, people over the age of 18 got access to vaccines, which of course means we are still going to be in limbo for quite some time before we can get to some level of normalcy in driving our advocacy agendas. So Gender Dynamics is a human rights organization that predominantly uses advocacy as a strategy to advance human rights realizations for trans and gender diverse persons. We primarily target the executive and of course the legislature to be able to advance change and use litigation as a strategy of last resort, where no remedial action has been taken to, of course, secure the needs and see to the needs of our community members. In addition to that, our main advocacy, legal advocacy goal is to ensure that government passes legislation that recognize the right to gender recognition for trans and gender diverse persons on the basis of a human rights-based model, and specifically in light of the right to gender self-determination. And that would mean that we would, the medical requirements would be declared redundant, and we would also be focusing on gender recognition beyond the gender binary model that we currently see our government and other governments also adopting. And so a lot of this work then around law reform in this regard is currently being championed by the National Gender Diversity Coalition that has been recently established in South Africa. However, whilst that process is ongoing, we still have the current piece of legislation in place, which is the Alteration of Sex Description and Sex Status Act 49 of 2003. And this particular piece of legislation is the legal mechanism by which trans and gender diverse persons and intersex persons are able to amend gender particulars with the Department of Home Affairs, very much based on a biomedical model. And of course, because there's no guidelines or regulations or standard operating procedures guiding the implementation of the regulations, of the legislation, it has resulted in a lot of gatekeeping and trans people not getting access to the recognition legally. One particular case that you spoke to is the KOS versus Minister of Home Affairs matter that was dealt with in 2016, that involved 6 applicants, and GDX was the 7th, Gender Dynamics was the 7th applicant. And it emerged from the problematic dynamics associated with Act 49. Here we had transgender persons who were married under the South African Marriage Act, and of course, applying to the Department of Home Affairs for gender marker change under the Alteration of Sex Description and Sex Status Act, being denied a gender marker change on the basis of marital status. Secondly, when we look at the third couple, their marriage after the gender marker change was done by the department, their marriage was completely deleted from the system. So it was nullified. And the court declared that this was unconstitutional and unlawful action. And so we've been struggling from that point up until now with implementation of this court order. And COVID-19, of course, has made it exceptionally difficult for us to be able to hold government accountable, because last year when we tried to set the matter down for hearing again with our legal partner, in order to compel the department to implement the court order, we could not get a hearing date because of the clogged up court roll. That, of course, is the result of COVID-19. And so at this point, we've been able to make somewhat of a shift after the matter was then set down for July, whereby an extension was granted for the Department of Home Affairs to comply with the court order and implement that by the end of September. So we are really waiting and looking with bated breath in terms of what's going to happen and whether the department is going to hold true to the promise of implementing this court order. So I will park there for now as introductory remarks and unpack a little bit more on these dynamics later on. Thanks, Sibonzile.
Brilliant, Liberty. Thank you very much for that very comprehensive introduction there. Let's also now bring in Ken Youngman, who will speak in particular by giving us a status update on the DCRIM case, as well as the Attorney General's decision to appeal the judgment of the High Court. Kane, good morning.
Good morning, Dumelang. Maybe just also to give you a background of who Botswana is. Botswana is one of the most secretive nations you've ever experienced in the world. So if you have a secret, Sebenzile, and you want it well protected, you should bring it over to Botswana. We're very good at keeping secrets. We're very, very good at denying things. I mean, our country, just to give you the context, we are a very patriarchal society. We have had the same ruling party since 1965. We have this approach to life that if it's not broken, why fix it? And that works very well with people who are secretive. I mean, if you keep it under wraps, then you can easily tell people you don't have to fix it. So it was the same thing that we kind of experienced when we came out in the open as Lehabi was the LGBTIQ plus community of Botswana. It was the same thing. It's like people were like, what exactly is it that you want? We had to seek public perceptions from that complete shutdown and complete ignorance of the LGBTI community, where people did not want to talk about the LGBTIQ plus community at all, where everywhere would go, we would be met with silence. We had to shift the perceptions from there to people start to appreciating that we are there, and they started calling us demonic and uncultured abomination, and we had to shift them from accepting to say, yes, they are Botswana, but they should not hit on us, they shouldn't come close to us, and all those things. So all the way from there to where we are right now. So the decriminalization case was about, we're basically saying to the community at large that we have been sitting in silence for many years. Our right to privacy, our right to dignity, our right to liberty, and our right to be protected against inhuman and degrading treatment have been trampled upon for many years. And this has been caused by the so-called statute, the statute we call Penal Code. So we went to court through one of the members of the LGBTI community in Botswana called LM. So Lekhabibo appears on the case as amicus curiae, as a friend of the court. So we're basically trying to give the court a perspective to say to the courts that this case is beyond this one individual. This case affects many people, and we had to demonstrate to the court how this case affects one, so that they have an understanding that it is not just about the name that appears on paper. It is way more than this as an individual. So then we were victorious in 2009. And then the Attorney General decided to appeal. And the appeal was kind of unstructured, because you know how the judgments are labeled in paragraphs. So they decided to appeal just about everything. They said the courts had made a mistake, have erred in their judgment. So to date, we're still waiting to be given a date with the High Court. So what happened was, because of the case is about the liberties of the LGBTIQ community in Botswana, not just the LGBTI community, but because we are focused on the LGBTI, I'm specifically going to talk about that. So because of that, because of COVID, we had to have our liberties put on hold. We have been afforded these liberties by the courts, by the High Court of Botswana. And then the Attorney General appealed. That appeal on its own says to Botswana, we really believe that the so-called LGBT community should not be afforded these rights. So the appeal basically says that. And the fact that the case is not being heard because of COVID, it basically still says to an ordinary Botswana that yes, indeed, the LGBT community should not have been afforded the rights that they have been afforded. Because people have a misconception that this case was about asking additional or superior rights. No, the case was just about basically trying to get the court to say, for many years, as the LGBT community, you have always been short-staffed with your rights. Everybody has been given, for lack of, just hypothetical, let's say everybody gets 10 rights, human rights afforded to them. You, as the LGBT community individuals, you are afforded 4. So right now we want to give you the other 6 so that you are at par with everybody. So that's what it's about. So COVID has kind of restricted that, it has kind of stripped those rights away from us. In addition to what is going on, we have community who are facing mental health problems. The mental health problems of the LGBT community has since increased in immeasurable amounts, because we have experienced lockdowns, and lockdowns means that you cannot leave the house even if you want to. It means if you are living in a hostile environment, you have to deal with that day in, day out. You can't leave. And as LGBTIQ communities, we usually provide emergency shelters for our community. So during the lockdowns, it meant that even if we want to provide you with emergency shelter, we can't, because during the lockdowns, all resorts were locked down. And because of, in a country like Botswana, we have a population of 2 million, and we have only 2 emergency shelters in the entire country. And because of COVID, shelters are not allowed to accommodate people to their capacity. So they're possibly allowed to accommodate about 40% of the capacity. If a shelter can usually accommodate about 20 people, it meant that now they had to reduce that. It will have to go to about maybe 8 if that's 40%. Yeah. So, and thanks to COVID also, we have some members of the community who got laid off work. Especially for this part, I'm going to focus mostly on the trans-identified community, especially those ones who have already started transitioning. Because in Botswana, the government of Botswana does not provide transitioning assistance, does not provide health services for trans-identifying individuals, trans-specific health services. So if you are transitioning, you have to pay from your pocket. So because of that, if you are laid off work and you couldn't afford to pay for yourself, we had people dealing with hormonal adherence issues because of COVID. So as an organization, we had to kind of step in and assist some of the individuals who experienced problems. I think maybe let me stop here for now, because I feel like I'm getting in the spirit. I'm about to start talking at length.
Good place to pause. Okay, thank you. And we'll come back. We'll come back to that, particularly the point around moving beyond the individual litigant towards progress, towards the development of a policy on legal gender recognition. We'll get to that in a moment. Let me invite Melusi Smelane to speak in particular on the state of play, Eswatini, and of course with a particular focus on the registration case of trying to get EGSM registered. Melusi, good to have you with us. Good morning.
Pleasure. Good morning to everyone watching us from everywhere in the world. We're saying good morning because Africa is at the center and the heart of everything. Melusi Smelane, of course, is my name, as I've been introduced, and I'm from Eswatini. I'm founding director, actually, of Eswatini Sexual and Gender Minorities. I think it's important for me to, before speaking about the work that we're doing, focusing on LGBT activism and advancing human rights of LGBT people, to speak to the current pro-democracy protest, or people are calling it civil unrest, that's been happening in the country. And I think it's important that I start there, because that in itself sort of shed light in terms of the socio-politics in this country, where there's this continuation of trampling on the fundamental rights of people. And I've spoken in spaces where I have said, I'm grown now, and I don't think it's fair for me to see the discrimination that I get as an LGBT person from the state as a badge of honor, to say it's because I'm a gay man that I'm being discriminated by the state, because the state has demonstrated time and time again that they refuse to allow people to enjoy their freedoms. Case in point, the right to freedom of association, the right to freedom of expression and speech, which then brings me to the issue of the organization that was started, Eswatini Sexual and Gender Minorities, which is one of the first to publicly advocate for LGBTQ issues in the country. And because we sort of created this queer visibility that was so massive, the state then decided to stop us from being registered formally as an NGO. And in that denial to register us, they raised important legal questions around the issue of association. And then it's where they, as Kane has already mentioned, the issue of this colonial criminalization of same-sex intimacy between men was then used to also, refuse us registration. So I think since then, which was 2019, we have tried as an organization to operate without the formal registration, because we then brought the matter to the courts, which was held October of 2020. So while we were doing that, we've been able as an organization to sort of push the conversation forward. We started something called an annual LGBT conference in the country, which we convene every September. And convene in September because we have decided that September is very important for us as an LGBT community. community. For those who know Eswatini will realize that September 6th is the Independence Day for the country. But we have said, as the LGBTQ community, we were left behind because we're still being impacted and affected by this colonial common law offense of sodomy, right, which is a colonial era law, but it continues to affect us as an LGBTQ community today. And some might argue that, well, no one is being arrested under that law. And then my argument would be, we cannot enjoy our right to freedom of association because of that law. So that gets to show you how these sort of colonial legacy laws continue to affect us as an LGBT community. And I think just to touch based on what was raised on our last conference which was held last year, was the issue of the trans community and the lesbian community, which continue to be left behind in terms of advancing the rights of queer persons. And I think, again, we touched on the issue of mental health for LGBTQ people. And I think I'm happy to announce that as of August 1, the organization has been taken over by a lesbian woman. And I think that also gets to show the importance and the commitment, rather, of the organization through its board and its membership to make sure that we are moving with time and we are seeing where there is a gap, that we fill that gap. And I think it's important that I mentioned that Sisanda, who's the new executive director of the organization, is going to take the organization forward in terms of ensuring that we have an intersectional approach in the advocacy that we are doing. We are membership-based, so every decision that comes from this organization comes from the members, but at the helm of it and at the peak of it must be people who will understand intersectionality and a feminist approach. So yeah, the situation in the country has been quite tough because, again, of the recent sort of uprising or pro-democracy protests. But when it comes to COVID-19, I think it's fair to say, and this is the same everywhere in the world, I believe, that the pandemic has actually affected the LGBTQ community more than it has other people. And the reason is because the LGBTQ community has been disproportionately disenfranchised. I mean, historically, when it comes to issues of socioeconomic and access to education, access to just basic human rights services. So when the pandemic came and then everyone now had to forego some of their liberties, we as a community felt like, well, we're used to this. So now this is becoming a double-edged sword to us because we were already disenfranchised. So now you are further, putting us into a box where it's been hard for us to survive. And, thanks to the limited resources that we've been able to mobilize around partners like the Other Foundation and other donors around the world, we've been able to sort of provide, that leg for the LGBT community to continue surviving during the pandemic. And I look forward to having more conversation on that. Thank you.
Fantastic, Melissa. Perhaps we'll stay with you for just a moment as well on, and I'm glad you've framed it around, the recent unrest, which isn't over, right? And we're watching closely to understand where it will go. But for LGBTI plus activism in this one COVID-19 context, but also the context of unrest, of uprisings of sorts, where there's a different conversation that's being had in the country. What does that look like? Are there fears that the issues of the LGBTI community may perhaps get lost in there, or are they in fact also amplified, where you were able to say, but we have been at the receiving end of the most of the repression, really, from the state, and now it seems as though everybody else is now part of it. So is this an opportunity for these issues to be amplified, or is there also the fear that they may get lost in the rest of the conversations?
I think I believe so much in this ideology of collectivism, rather, and I do not believe the issue of the LGBT community and how they have been disenfranchised in the past would get lost, especially if we have activists who are going to stand their ground, who are going to continuously speak about this. And if you follow even most of my Facebook page posts recently, I've been talking about the importance of not forgetting that there is an LGBTQ community within this movement that wants democracy, within this movement that wants a recognition of basic human rights. And I think in most cases, what we tend to do as a society is to generalize, in a sense, trying to say, well, we are going to make sure that we cover human rights. And I think personally, I want for us to be able to call it by its name. When you're saying human rights, what do you mean? Because human rights are broad. I mean, every dictator in the world can come to you and say, well, you have your human rights, you have your right to life. So how do you counter that? You need to call it by its name. And I think it's an opportunity, Sebenzile, you're right, for us as an LGBT community to come to the fore. Yes, there is backlash. Yes, there are those who would rather not discuss this because, I mean, this is something that has been happening in politics many years before we were even born, the issue of saying, well, let's not talk about this issue now because it's going to muddy the waters. So I think that thing exists, but it should not, demoralize us. Actually, it should be an indictment to us as activists, as believers of social justice, to say we need to come to the fore and we need to make sure that our issues are involved. And if we are not doing that, then of course the issues are going to get lost in the whole movement.
Mm-hmm. Absolutely. Liberty, please jump in on that point. And I know we spoke quite a bit about South Africa earlier, but open it up a bit for us and give us the regional picture and what trans advocacy, trans activism in this context is looking like.
Certainly, Sebenzile. And I think touching on where we are at and the point that I made earlier on, that a lot of our energy and focus had to go into service delivery as opposed to advocacy, which is, of course, coming part and parcel of the time that we're living through. In South Africa, if we're looking at the stats, unemployment increased from 25% to 41% at some point in the pandemic. And of course, LGBTIQ plus persons would have been most affected by that because of stigma discrimination that still plays itself out within this context. I think one of the components that the COVID-19 regional response project sought to address was to ensure that to some extent we could contribute to alleviating some of the socioeconomic insecurities that people were living through, and particularly trans people across the region. This included PPE, it included access to emergency shelter and transport, it included access to food security, data security to be able to connect online and be able to connect with service providers, etc. And so looking at a lot of the requests that has come through to the organization, it is along the lines of hormonal insecurity in the region. So at the peak of COVID-19 throughout, we have had requests of trans and gender diverse persons for access to hormonal care because at an in-country level, that level of care was either not available or there were hormonal stockouts because of the closing of borders and nothing filtering through to the community. And so for us, that becomes a key priority to look into in terms of and driving a clear advocacy agenda. How do we enhance the quality of life of trans and gender diverse persons by looking at hormonal security across the region and how we can promote transnational access? Because in many regards, when that level of care is not available in country, our siblings are depending on solidarity from elsewhere in the region to be able to support the need. And I think that is a core priority for us. Second to that, the issue around legal gender recognition. I think that the biggest error that we often make is that because law exists in one way or another, whether that has been legislated on or whether it has been through judicial decisions, mandating that law be implemented to that extent. When we are departing from a biomedical model like we are doing in this region at this time, where legal gender recognition exists, it's very problematic because it is linked to the healthcare system. Now, if you don't have access to gender-affirming healthcare, it means you will not get access to legal gender recognition because you do not have the required proof to accompany an application to a Department of Home Affairs or whatever that is called at an in-country level. So a priority for us is also to de-link the healthcare requirement from the legal process of getting a gender marker change, and that speaks to gender recognition on the basis of gender self-determination. In terms of looking at where hormonal care and gender-affirming healthcare is currently being initiated, it's being done at a tertiary healthcare level, and that is typically situated within your larger urban centers. So trans persons located on the periphery of cities or in rural contexts are not able to get access to it by virtue of geographical location. So exploring models of decentralization of care that would speak to the needs of the most marginalized in our communities is a clear priority for us now moving forward. And that, of course, is shared across the region by and large.
Mm-hmm. Brilliant. Thank you. Thank you, Liberty. Kane, let's come back to you. We're going to speak more to the point around moving away from the individual litigant to towards or progress in developing policy and legal gender recognition. I think it also it's a good segue as well from Liberty's last point.
Okay. So in 2019, the trans diverse community met, and then in an attempt, the reason why they met is that we have two precedences, court cases, one called ND versus the state, and another one called Ricky Tsepokositau versus the state. This is about two individuals, trans-identified individuals, who wanted to have the identity documents speaking to the individuals that they are. But when they approached the state to have the identity document changed, the state said no. So because of that, they took their matters to court and they were victorious in court. The ND went all the way and was victorious, and then a court judgment was given and all those things. The Kositau case, in the end, the state kind of withdrew and just the court had to give a court order for her to change her identity documents. So what has been happening? We're saying the trans diverse community tried to go to the ministry responsible to change this identity documents. In Botswana, that ministry is called Ministry of Nationality, Immigration, and Gender Affairs. So most of them, the trans diverse community that went to try and get the identity document changed, they were sent back. They were told, go back to court and get a court order. Mind you, I consider myself to be a working person and very comfortable and earning an almost comfortable income. So now what they are asking people, and I even though I earn a comfortable income, I still don't consider myself to be able to afford to take matters to court, to pay lawyers, because lawyers charge by the hour and the figures are just quite exuberant. So now you're asking every individual from every background, people without income, people without any means, to go through the courts. One, you're not providing them with free legal service. Now you want them to fight to have the identity documents speak to the people that they are. So the trans diverse community then sat around the table and had a discussion, and they had a mind to develop a policy document that we call the legal gender recognition. This policy document was to help this ministry, was to give them guidance, to say, okay, we do understand that you don't have the capacity to understand how this impacts our lives as the trans diverse community. We do understand that you probably don't have the time to put in the effort to learn about us. So we are developing this document to make your life easy and to make our lives easy as the trans diverse community. So this document was giving guidance to the ministry to say, when a trans identifying person comes to you and requires to have the identity document changed, have this in mind. This is the process that we are proposing that you do. We should not be having every person going through the courts of laws. The document spoke about the cases that took place in Botswana, it also gave them best practices from other countries to say, learn from these other countries. This is how they did their things. This is what we are recommending that you do as the ministry responsible to deal with our identity documents. But unfortunately, we're still waiting. So, and it's unfortunate that this kind of came in when COVID had just happened. Because what we had done, we had structured ourselves. We were working together with the trans-diverse community. We formed a little committee, and this committee was tasked with going to different government departments, was tasked going to meet different legislators to try and teach them about this policy brief, to try and teach them what it means to deal with trans-diverse clients, what they should be doing, how they should be doing it, and what they should not be doing. But it's unfortunate that nowadays, every time you try and go there, you get told either the officers are short-staffed. One, the officers are working at a certain quota. They're not supposed to work at least not more than half the office. And then sometimes, as it is with every institution, you get there, you'll be told, oh, the officers are on isolation. They're either gone for 2 weeks or they're either gone for 3 weeks. So we have this beautiful guiding document that we're itching to have somebody come to the table and listen to us and adopt it. We don't mind, even if they can adopt it and say it and claim all the glory and say we've done this. No, we don't mind. What we want is for the community to be able to change the identity documents without a hassle. Because at the moment right now, the vaccine rollout in Botswana has been taking place. So we are standing guard. We are wondering what is going to happen now when Kane comes, as bearded, as grizzly as he is, with an identity document that perhaps says Cynthia, young man, and it has an F. And Kane comes because he has been transitioning and he's like this. Is he going to be allowed to take the vaccine? Or his life is going to be put at risk and he will be turned back and sent back home? Because the ministry responsible has refused to change his identity documents. So all of this, Sebenzile, sometimes it always leaves me wondering. Sometimes I always ask myself over and over again, why is it that we as activists don't suffer from high blood pressure? A lot of us, at least 90% of us, because all of these things are infuriating. Every time I think about some of these things, my blood pressure goes up, because it's like one thing, the statement that when you were in your opening remarks, you mentioned that one thing I like is that it's the same kind of principle that we have adopted as Lekhabibo. It's about, we don't want to be infused into a system that is oppressive, that is abusive. What we want as Lekhabibo is to iron that system out, is to straighten it up and have it inclusive of everybody. That's exactly what we're trying to do. But at the moment, COVID is not allowing us to do that. Yeah. We experiencing problems with COVID because we are trying to reach out to, we are a service provision community, and we understand that there are people in rural areas across Botswana. And rural areas across Botswana means that people don't have smartphones. So we can't have what we're having now. We can't have this kind of engagements with people in the villages. And at the moment, we have travel restrictions. For you to leave this zone to go to another zone, you need a permit approved by the government. And sometimes they deliberately shut down the system, and it's like every time any person who tries to apply, you get an automatic no, try again tomorrow. So people in the villages, it means that you have to have a smartphone. If you don't have a smartphone, you can't have this kind of setup. Yeah. And you also have to have bundles. And bundles, mind you, internet bundles don't come cheap in this country. They're expensive. And in addition to that, we have issues with power. Villages don't have electricity. Not a lot of villages have electricity. Even if those who have electricity, we have our own kind of ESCOM in this country that always that takes away its power whenever it likes. and it's not necessarily scheduled. So COVID has, in a way, made sure that the communities, the LGBT communities in rural areas, are kind of left in those without us getting to them with something.
Let me ask you to pause there, and thank you for that. I just want to get to the Q&A because we are fast running out of time, and just encouraging folks who are joining us or watching, of course, on the stream, on Facebook, and in the room as well, to get in those questions as we only have just a few more minutes left together. But here's a question here from Katleho, who asks, regionally, a number of countries use strategic litigation as a main tool for achieving legal and constitutional change, noting that various countries have different contexts. Is the approach to strategic litigation used purely as cut and paste? That's the first part of the question. And then the second is, apart from the courts, what other approaches are countries using to achieving change, particularly toward attaining legal gender recognition? Who wants to take on that, or perhaps taking one part? And then as you think about that, let me give you a second to think about that. A question from Tutu. Tutu asks, does Lekhabibo have a case studies document that one can tap into to learn from the experiences? It seems like Botswana, Swaziland are in the same WhatsApp group in terms of the secrecy. Lekhabibo has somehow managed to penetrate a little bit. Great questions there. Can perhaps you can think about that second one as well, Melusi, you as well. But also just starting off with Katlaho's question. Liberty, can I pick on you?
Sure thing, Sibenzile. I think that definitely strategic litigation is not a cut and paste situation, because the legal, political context within different in each country is different. The socioeconomic context is different in terms of access to resources. So one would ordinarily want to understand that in depth before one proceeds to strategic litigation. I think for us, as an organization, we see litigation as a strategy of last resort once all of our efforts have failed, because in the South African law, most likely you're going to find a provision that states that before you approach the court, you must display that all internal remedies have been explored. So it means that you have appealed the matter up until the most senior person within the administration in order to get a response. If that is unfavorable, then on that basis, you may proceed to litigate on the matter. And I think that in terms of the limitations of strategic litigation, for us, it has meant that non-implementation of court orders, for one. And so you would still need to some degree to get government to a point to have to implement that court order. And so that has been challenging. And on the other end, the powers of the court by its very nature is also very much declaratory in nature. And if it instructs, it cannot create new law. It can give some guidance as to what is wrong with the law, what is unconstitutional, what is unlawful. But the powers to create new law would still rest with the legislature in essence, looking at the doctrine of separation of powers. And I think for us, there's a lot of work outside of strategic litigation that we then need to look to in working with the administration and working with the legislature. And that is painstaking and long work in and of itself. Some of the strategies that I think have worked for us has been investing in community education to galvanize the community in coming along, understanding the issues, and being able to speak with a united voice, being able to collectivize our voice as civil society and not working as one, and hence why we established the coalition to say that if we are going to be working in silos, we are likely not going to achieve anything meaningful. But if we collectivize our efforts, we can have a much more powerful voice. And then, of course, at the end of it, being very clear around what the objectives and the priorities are, because in many instances, if we are not collectivizing our efforts, it means we can say contradictory things. And so research assists us in getting clarity around what our objectives are for advocacy and to be able to show the evidence as to why we are pushing for a particular agenda. And I think for us, we've really found that to be quite useful. The last component is capacity strengthening, even if it is small, informal type of engagements with decision makers and decision influencers, whether or on the other end being fully fledged trainings around what our needs are as communities. That is also very much necessary to hold the line for strategic impact through strategic litigation in the work that we do.
Brilliant.
Okay.
Thank you, Liberty. Melusi? Before the second question, Kane, let me just bring in Melusi to also speak to that question.
Yeah, I think it's a fantastic question from Katlego, the issue of copy and paste. Though I might think it might look like copy and paste, but I don't think it's necessarily copy and paste in the sense that we live in the same region where the jurisprudence is almost similar. So you are bound to find the same legal arguments from the state of Eswatini that could have been used by the state of Zimbabwe, for instance. I remember on our registration case, when we were in court, someone from the Attorney General's office came in rushing with some paper and they threw it at them. And then they started making an argument that, of course, you can't discriminate against the person if that provision is not in the Constitution. So this was on the question of whether we can be discriminated on the basis of our sexual orientation because the Constitution does not explicitly say so. And they were using an argument that was used by Zimbabwe some time back. So I think it is possible that we are going to sort of use the same arguments because the jurisprudence is almost similar. But like Liberty has said, I don't think it's necessarily a copy-paste. It's just an issue of does the strategy work here or does it not work? And then on the issue of, I think the second issue, Liberty has answered broadly on it, on Katleko's question. So mine was just to clarify on the issue of copy-paste. I don't think it's copy-paste. I think it's just using the same strategy because we live in the same region. I mean, we should forget about the borders. They're very colonial.
Brilliant. Thank you. Thank you, Melusi. A quick comment from Facebook, and then I'll pass it on to you, Kane. Someone here says, I think it's Virgilio from Mozambique, who says, in order to minimize COVID-19 in Southern Africa, we must not only put prevention measures in place, but also act with these prevention measures, train in each country and each province of each country, people who can pass by the markets in the neighborhoods, giving lectures, some tips, materials to prevention, and warning people in the region not to panic, but also give a helping hand for survival because people suffer. And you who are rulers of the nation depend on the people to rule, but essentially promoting awareness as well within amongst communities. Came the question about how you can share experiences more as Lekhabibu with the region.
Okay. For that one, it's easy. Lekhabibu is always open and available to share its lessons. We have already been approached by comrades from Eswatini. We have already been approached by comrades from other countries, even comrades from Zimbabwe. So we are brothers and sisters. We are siblings. We are all children of Mother Africa. So we are always open and available for engagements to share our lessons. And in addition to what my comrades Liberty and Melusi have said, strategic litigation for us is not a main tool. Contrary to popular belief, I know we are known for our victories in court, but it is not our main tool. Before strategic litigation, I came into Lekhabibu with my hair black as a charcoal. And because of the background work, because of the work that we do behind the scenes, I ended up being like this. And I started appearing with strategic litigations with my hair already gray because of the background work that we do. For us, strategic litigation is just a small tip of an iceberg. We do our main things, the main tools that we're doing is community engagement and education. Because we believe that it's important. We believe that if we invest in community engagement and education, that one is more sustainable. It builds the community, it makes them stronger. That should organizations be outlawed tomorrow? Should institutions cease to exist or cease to exist because of funding? Communities should be able to challenge the powers that be by themselves. Communities should be able to hold the powers that be accountable. So for us, that is the main tool that we use. Strategic litigation is just one of those things that we use as last resort to try and push the government, especially when the government tries to play impossible or where they deliberately don't want to do certain things they're supposed to be doing, where we just have to force the arm and say, you know what, we have tried to be civil, we have tried to be accommodative, we have tried to be polite, to come to you and show the shortcomings and say to you, this is what needs to be done. And you did not do it. So we're going to force your arm to do it. So the copying and pasting, cut and paste never works, because even though we are born to the same parent, we still have our own autonomy. We are still different. So it never works. It will never work. We just have to be strategic, as the word suggests. We have to be strategic, and we have to be very much cognizant and very much alive to the context that we live in. We have to analyze every single thing that our context offers us. And we also have to be time conscious. That's the same thing that we did at Lagadiwo. We had wanted to challenge decriminalization in 2011, 10 years ago. But we ended up withdrawing the matter because we were time conscious. We did an analysis of our environment and say, well, in other countries might have done it, but we feel like if we go ahead and do it now, we are setting ourselves up for failure. So you also have to be time conscious when you talk about strategic litigation. Thank you.
Absolutely important, Kane. A fantastic point there. Melissa, I see your hand is up. In addition to the point you want to make, please answer this question as well from Blessing, who asks, what can European governments do to help African countries address challenges that the African LGBTI plus community face?
So can I just make my point and then we'll go back to that question? I just wanted to agree with Kane on the issue of not relying heavily on strategic litigation, because, I mean, the other thing that Kane has already mentioned, courts are very expensive. So what happens if we lose the resources to go to court? But I think for me, the other point that I wanted to make is that sometimes these courts are not as independent as we would like them to be. Right. So if you rely heavily on that, you are never going to win. It's either you're just going to lose or they are going to delay you until you get tired. So I think Kane is right. We do need to invest so much in the changing of hearts and the changing of minds. And this is something that at Eswatini Sexual and Gender Minorities we're doing recently, which is speaking to these traditional leaders at community level. We have people who are community caregivers called Batu Tudeli, or Tinvuna Temtuba, who is the chief minister in that particular chiefdom, so dealing with those people at community level so that we can change hearts and minds. So I think it's very important. The question was, how can European governments do what?
Assist African LGBTI communities.
I hate to say this, but resources. And when I say resources, I'm not just talking about money. Money, yes, but I think also in terms of capacity building, I think in terms of skills sharing, knowledge sharing, because we know I was in Germany the other month or other year, and I was shocked to realize that the LGBT movement there is as old as time. I mean, they were talking about even during World War II. I mean, of course, I hate myself for not being a student of history, but to talk about how LGBT people were actually affected by World War II with the Nazis there. And there is so much that we can learn from those people in terms of how they dealt with that, because we are better. I always say in Eswatini particularly, we are better because we are not being arrested or paraded like some other brothers, sisters, and others are in the African continent. So we need to learn from each other in the continent, but also we need to learn from each other outside of the continent. And I think European governments and European people, philanthropists, must always be ready to give us resources and not just money, because in most cases, they have lost it by just giving us money and then leaving us out to hang. And you will find that without the capacity, without monitoring and evaluation, and actually showing the skills in terms of how do you manage and how do you deal with governments. I mean, yeah, we're a global society now. Our governments are being battered up by these Europeans, right? So we need to also get a political push on their side to say, remember your conventions with Geneva, remember your obligations with UN conventions. So yeah, I hope I've answered that.
Absolutely, absolutely. A quick one from you, Liberty, on the same question. We are already 2 minutes over, so 30 seconds, and then we wrap it up.
Responding to the same question, Sibenzile?
Yes.
So I concur with Melusi. And in addition to that, those resources need to go towards strengthening human rights infrastructure and machinery on the continent, because we are very much dependent on strong human rights systems within countries to be able to also advance our particular perspective on human rights realizations for queer communities. So that would be a priority thing from my end. In addition, I think that a lot of resources need to go in excavating the narratives of pre-colonial Africa in the context of queer identities that existed in pre-colonial times. I mean, the laws that we have today are colonial constructs that which outlaw same-sex consensual sexual conduct, where we are looking at gender through a binary lens. We have a very rich history that speaks to the fluidity of sexualities and gender identities. So being able to use that history and take that as something that is us and not something that is Western and foreign to the continent. And of course, if we're looking at some of the ways in which the West have also been supporting some of the work, being very clear about differentiating that agenda, because that is also when we are taking it as a Western agenda, then it also deters from the type of work that we can drive on the continent, because our people do not see themselves reflected in the discourse that we are pushing for and the change that we are pushing for.
Yes.
Brilliant, fantastic way to end it all. We could go on for hours on end. Thank you very much.
Just a one-liner.
Okay, 30 seconds. We're over time. We're over time.
I'll definitely take less than 30 seconds.
Okay,
yes.
Please.
For me, what they need to do, they need to listen to us. Not just do things, but it's important that they listen to us, because we know what we need and we know what we want. And two, they need to be willing to open doors for us. Because consider, weirdly enough, we have people, our legislators, we are their constituents, we are their voters, yet their doors always remain shut for us to come in and engage with them. But their doors are always open for foreign nationals, for diplomatic missions. So hence why I'm saying they need to listen to us and they need to open these doors for us, because our leaders deliberately always choose to close doors to us, their constituents. Thank you.
Brilliant. Thank you very much. And thank you to our attendees and people watching on Facebook as well. The great thing about social media as well is that you can go back to it and watch it, because it'll live on our Facebook page as well as the other foundation. Thank you very much as well to the Danish Embassy in South Africa for the support as well. They've given the other foundation during World Pride as well for World Pride activities. And thank you, Melusi, Melane, Kane Youngman, and Liberty Matesa. We are deeply grateful for your time with us today. And that's where we wrap up our focus on litigation and policy reform in Africa today.
Take care, everyone. Bye.
Sehr bon.
Sibenzile, can we log off? Are we still live?
We're still live. You can sign off.
Okay. Bye, everyone.